Hi, folks. Thank you for joining us tonight. We will get started in a few minutes. We're just trying to give people time to join. Thank you, everybody, for joining. We're going to wait one more minute for folks to keep on coming in, and then we'll get started. All right, we will go ahead and get started. Thank you so much, everybody, for joining us tonight for DC Decision-Making Tools for Healthcare. We will be using information from the Counsel for Court Excellence's Community Education Guide when adults need help to talk about some critical decision-making tools for healthcare. My name is Casey Anderson, and I am the Communications Manager at the Counsel for Court Excellence. The Counsel for Court Excellence is a nonprofit, nonpartisan civic organization. For nearly 40 years, CCE has worked to improve the system of justice in the District of Columbia with the goal of having it serve all members of the public effectively and equitably. CCE conducts research, identifies and promotes justice system reforms, brings together interested and knowledgeable parties to collaborate on the development of sound policy and the advancement of positive change, and educates the public about the justice system in the District of Columbia. Among other educational efforts, CCE has published and distributed over 300,000 copies of plain language booklets, guides, and other materials explaining various areas of law and court processes in the District of Columbia. You can find electronic copies of these guides at CCE's website. And CCE published the When Adults Need Help Guide, and our lovely panelists tonight contributed greatly to this guide. So we're really lucky to have them here today. Now our panelists can introduce themselves and their organizations.
Good evening. My name is Holly Caesar. I'm the Jenny Hatch Justice Project staff attorney at Quality Trust. Quality Trust is an independent, nonprofit advocacy organization dedicated to effective advocacy and legal representation for people with disabilities. For nearly 20 years, Quality Trust has worked to improve the lives of children and adults with disabilities and their families in the District of Columbia. Quality Trust works with individuals and family members to solve problems, identify opportunities for learning and contribution, and find creative ways to minimize differences and make the most of each person's abilities. Quality Trust Jenny Hatch Justice Project is dedicated to advancing the decision-making rights of people with disabilities and helping them avoid undue or overbroad guardianship. We provide legal assistance to DC residents who have questions about their decision-making rights, who are in a guardianship that are unhappy with, or want to explore less restrictive forms of decision-making support, such as supported decision-making agreements, powers of attorney, advance directive, and other legal options. Next slide, please.
Hi, everybody. I'm Jessica Bromson. I'm an attorney at Legal Counsel for the Elderly on their legal hotline. Legal Counsel for the Elderly, or LCE, provides free legal services to DC residents over the age of 60 or 55 for Social Security benefits. We assist people in a variety of legal areas, including public benefits like Medicaid and SNAP or food stamps, Social Security benefits, consumer issues, home foreclosure prevention, landlord-tenant issues, and things like powers of attorney and guardianship. We provide short-term legal advice and referrals through our legal hotline and our self-help office. And we also have attorneys who provide longer-term representation. Additionally, LCE advocates for legislation and policies that improve the lives of seniors in DC. And I like to note that there's no financial eligibility requirement for our legal hotline, meaning that people can call us for legal advice regardless of their income or assets. However, a caller does have to meet certain financial eligibility criteria in order to receive free long-term representation from LCE. Next slide, please.
So you have met 2 out of our 3 presenters tonight. So Morgan, would you like to introduce yourself?
Yes, thank you. So hi, everybody. My name is Morgan Whitlatch, and I'm the Legal Director of Quality Trust for Individuals with Disabilities. I'm really happy to be here today with such great panelists and to be promoting CC's great guide. So thank you.
Thank you so much, Morgan.
So on this slide, you'll see an overview of the legal tools that we're going to be covering today. And the list proceeds in order from the tool that's the least restrictive to the one that's the most restrictive. And when I say restrictive, I mean restrictive in the sense of restricting a person's decision-making rights. So we're going to start with the newest, most flexible, and the least restrictive tool, which is supported decision-making. In the right circumstances, supported decision-making can be highly effective, and it's really beneficial for a number of reasons. It doesn't require a lawyer or the court, it avoids restrictions on a person's autonomy, and it avoids the rigidity of the more traditional tools of guardianship and conservatorship. And it's consistent with an overarching principle of DC law that supportive arrangements allow for the greatest degree of self-determination, and taking into account the mental and physical limitations of the person that needs help. We're also going to cover some other tools, including advanced instruction for mental health treatment, durable power of attorney for healthcare, substitute healthcare decision-making, and guardianship. And what I'd like to emphasize is the importance of finding out what the person's needs and wishes are, and then focusing on which tool is going to be effective, but also the least restrictive of their rights in making their healthcare decisions. Next slide, please.
The age of majority in DC is 18. That means that when a person turns 18, they're considered an adult and presumed by the law to be able to make their own decisions, even if they have a disability. And there's a strong statutory presumption of capacity in DC. Under the law, an adult 18 or older shall be presumed competent and to have the capacity to make legal, healthcare, and all other decisions for himself or herself, unless certified otherwise under the DC Healthcare Decisions Act, which we will be discussing more today, or deemed incapacitated or incompetent by a court. Under the law, incapacity shall not be inferred from the fact that the person has been hospitalized for mental illness or has an intellectual disability. In the past, when an adult with a disability needs support with decision-making, the traditional advice was to go to court and seek guardianship, even when all the restrictions and protections of guardianship were not necessary. Now, however, there are less restrictive, less formal, less expensive options that should be explored first. Next slide, please. So what is supported decision-making? At its most basic level, supported decision-making refers to a common everyday practice with which we are all familiar with. That is, asking for the advice or thoughts of another person or persons before making an important decision. It's given a special name in the context of people with disabilities to remind us that just because they may need more or different kinds of help in understanding the decision to be made, it does not mean that they're incapable of making the decision. In this way, supported decision-making can be seen as a reasonable accommodation for a person's disability. Supported decision-making refers to a broad range of arrangements that enable people to obtain guidance and support without giving up their legal right to self-determination. They can choose one or more trusted family members, friends, or advisors to provide help in understanding, making, and communicating significant life decisions while retaining the right to make those decisions for themselves. And studies have shown that people with disabilities have more, quote, self-determination, more direct control over their lives, usually have better jobs and a higher quality of life, are healthier, are better problem solvers, and are better able to fend for themselves and to avoid abuse. And supported decision-making has been acknowledged by the American Bar Association, the National Guardianship Association, and Department of Health and Human Services, among others, as a helpful tool for individuals who need extra help to make or communicate their decisions. And in May 2018, DC became the fourth jurisdiction in the United States to enact legislation expressly recognizing supported decision-making agreements. These agreements can now be used across the lifespan and in all life areas, including healthcare. Every person, institution, or agency in DC must honor a supported decision-making agreement that conforms to the requirements of the 2018 law unless it has good reason to believe that the person needing support is being abused, neglected, or exploited. Next slide, please. And we'll be talking about the specific supported decision-making form in a moment. But let's first talk about the basics of a supported decision-making arrangement itself, regardless of whether or not it is formalized on paper. There is no one-size-fits-all method for supported decision-making. Supported decision-making, regardless of whether or not it's in the healthcare context, is going to look different for different people. People have different needs and different support networks, and people have different ways of communicating. The key question is, what will it take to successfully support the person with a disability or older adult? It is critical that supporters work with the person and identify where help is needed. Supporters do not make decisions for the person with a disability. Instead, they help them make or communicate their own decisions, such as what medical treatment they consent to, which healthcare providers they pick, and what kind of end-of-life medical decisions they make. Supporters may also explain the choices the person faces in more easily understandable ways, ask questions for the person, help gather information, or assist with the person's communication to others. The supporter should be an adult that the person chooses and trusts, someone who wants to become their supporter and who wants to act in that role, who wants the person to make their own decisions, who is trustworthy and reliable, and who is not likely to hurt or exploit the person in some way. Next slide, please. Now, what is a statutory supported decision-making agreement? It is a way of formalizing a supported decision-making arrangement by putting it in writing. And the person with a disability, including older adults, can use DC's statutory supported decision-making agreement form, which complies with the requirements of the 2018 law. And CCE's When Adults Need Help guide also contains information how to get an electronic copy of the statutory agreement form. Next slide, please.
One important thing to keep in mind when using an SDMA form to formally record a supported decision-making arrangement is that there are special rules for who can be a formal supporter. Under the law, certain people cannot be a formal supporter under a supported decision-making agreement, and that would include support for healthcare decisions. There are two types of restrictions. The first restriction applies to people connected to certain governmental agencies or providers who are not relatives of the supported person. A formal supporter who is not a relative of the person can't not own or operate any entities that provide disability or healthcare services to the supported person. A formal supporter who is not a relative of the person also cannot work for a governmental agency that's financially responsible for the supported person's care. So depending on the person, that could include, for example, employees of the Child and Family Services Agency or CFSA, or DC Healthcare Finance, which is DC's Medicaid agency, or the Department on Disability Services, or DDS. But remember, these first type of restrictions do not apply if the supporter is a relative of the person. So you could be an employee of the DC Healthcare Finance and be the formal supporter of someone who receives Medicaid, provided that you are related to that person. Next slide, please. The second type of restriction on who can be a formal supporter using a supported decision-making agreement in DC has to do with illegal or wrongful behavior. Even if a formal supporter is a relative of the person who needs support, the general rule is that that formal supporter cannot have been found by a governmental agency to have abused, neglected, or exploited the supported person, or inflicted harm upon a child, older adult, or person with a disability. The formal supporter, even if they're a relative of the person in need of support, cannot have within the last 7 years been convicted of certain kinds of crimes, like sexual offenses or aggravated assault against a child, older adult, or person with a disability, fraud, theft of $1,000 or more, forgery, or extortion. The big exception to the second restriction is that these background requirements do not apply if the supported decision-making agreement is for educational decisions only. But after all, this webinar is about healthcare decisions, right? Not educational decisions. So these background requirements do apply to formal supporters in this context. Please keep in mind, though, we're talking now about formal supporters that are listed in a supported decision-making agreement. That doesn't stop supporters from helping somebody informally, even if they don't meet these two restrictions. Next slide, please.
So how do you make healthcare statutory supported decision-making agreement? First, you need to use a statutory supported decision-making agreement form. And Quality Trust collaborated with the Department on Disability Services to create a plain language packet that contains the statutory form, along with helpful information and instructions in completing this form. You should review the Department on Disability Services and Quality Trust instructions that accompany the statutory form entitled Information and Instruction Sheet, and it is linked in the CCE guide. And you should also circle yes to pick support in taking care of my physical health and or, quote, taking care of my mental/behavioral health. You should also consider circling yes for HIPAA release of information form and attach a HIPAA form signed by the supported person to the agreement. HIPAA is a Health Insurance Portability and Accountability Act, which allows healthcare providers to release and share medical information with parents. It's generally important for statutory supported decision-making agreements to include a completed release of information form to help facilitate the flow of information and communication. And under DC law, a statutory supported decision-making agreement has to be signed by the supported person and the supporter. They have to sign in the presence of either a notary or two witnesses, but it is good practice to use both. If an individual wants to use multiple formal supporters, it's highly recommended then that each supporter would need a separate statutory supported decision-making agreement. Next slide, please. You should also give a copy of the supported decision-making agreement to all of your healthcare providers. It's important that all of your healthcare providers know that you have a formal supporter. Also, for a statutory supported decision-making agreement, you do not need a lawyer or court involvement. And lastly, a statutory supported decision-making agreement is a flexible tool, and it can be canceled or changed by the person or supporter at any time. But it is recommended that changes should be done in writing, and copies should be given to the healthcare provider, the person with a disability, and the supporter. Next slide, please. Let's now discuss an example of supported decision-making in the healthcare context. Aisha has a severe learning disability and was recently diagnosed with diabetes. She's figuring out how to manage the new diagnosis and wants to make sure that she takes her medication properly and follows the diet recommended by her doctor. The medical jargon the doctor uses is confusing sometimes, and the doctor does not always know how to explain things. Aisha wants help getting answers to her questions in ways she understands. She also wants someone to go with her to medical appointments so that she does not miss any important information. She has a trustworthy friend, Diana, who is willing to help. Aisha completes a supported decision-making agreement form, which states that Diana will help her when she makes healthcare decisions by going with her to medical appointments and getting information from her doctors. Both Aisha and Diana sign the supported decision-making agreement in front of a notary public. Aisha also signs a HIPAA release of information form, which allows her doctors to share her medical information with Diana. Aisha attaches the release form to the supported decision-making agreement and gives a copy to Diana and her primary care physician. Aisha keeps her copies in the same folder that they are easy to find. And this is a perfect example of how a supported decision-making agreement can be utilized in the context of healthcare decisions. Next slide, please.
So now that we've talked about supported decision-making and supported decision-making agreements, let's turn to another tool that's called Advanced Instructions for Mental Health Treatment. DC residents who receive public mental health services from a DC licensed hospital or mental health provider can use an advanced instruction for mental health treatment to plan for emergency situations. In the advanced instructions, they would specify their choices for the services and supports they wish to receive in the event that they experience a mental health emergency and are unable at that time to communicate their mental health treatment preferences. For example, the advanced instruction might specify whom to call or not call in the case of an emergency. What medications and types of treatment or provider intervention has been helpful or unhelpful in the past for the person. Which hospitals the person experiencing the mental health crisis prefers. Who would make mental health care decisions in the event that the person creating the advanced instruction becomes unable to do so. By creating an advanced instruction, a person does not lose decision-making power. Instead, it's not giving someone else the authority to overrule the choices described in the advanced instruction document. Instead, the person creating the advanced instruction retains the power to make his or her own healthcare decisions unless two DC licensed professionals, a physician and a psychiatrist or psychologist, certify in writing that the person who created the advanced instruction lacks the mental capacity to make such choices even with support. And this option is described more in CCE's guide. An advanced instruction has to follow certain rules. It must be in writing. It must be signed and dated by the person giving the treatment instructions. And it has to be signed by at least one adult witness who is not related by blood or marriage to the person giving the instruction. That witness is not the person's doctor and is not an employee of the DC Department of Behavioral Health or a mental health provider. It should include a brief statement from the witnesses that the person making the advanced instruction appears to be capable of knowingly and voluntarily expressing the instructions included in the document. A mental health provider is expected to allow an advanced instruction unless it requests services or treatments that are illegal, are prohibited by court order, or pose a serious health risk. An advanced instruction is simple to write, and it's not necessary to hire a lawyer or to go to court to create an advanced instruction or to change or cancel it. It is, however, very prudent to do so in writing, which is going to eliminate confusion and create a record of the cancellation or termination. The change or cancellation can be implemented in a one-sentence document that's signed and dated by the person giving the instructions and an appropriate witness. Copies of that document that changes or cancels the advanced instruction should be given to any persons or institutions that have copies of the original. You have to put people on notice who got the document that it has been changed or canceled. Next slide, please. So let's turn to an example of when using an advanced instruction for mental health treatment should be considered. Daniel has been a patient on a psychiatric ward. When he has been hospitalized in the past, it has been important to him to participate fully in his treatment plan. With his wife's help, Daniel creates an advanced instruction for mental health treatment. He requests that in an emergency, his wife be contacted. that he not be given the medication Haldol because of his past bad reactions to it, and that the staff help him call his wife if he gets upset. Daniel gives a copy of the advance instruction to his wife, reviews the advance instruction with his treatment team, and asks that it be added to his medical record. When Daniel is hospitalized again, he is difficultly verbally expressing his treatment preferences. The treatment team reviews Daniel's advance instruction in his medical record, contacts his wife to let her know where he is, assists him in calling his wife, and offers him an alternative to Haldol. Next slide, please.
All right. Hello, this is Jessica again from LCE. I'm going to talk a little bit about durable powers of attorney for healthcare. So a durable power of attorney for healthcare is a legal document that allows one adult called the principal to appoint a representative called an agent or attorney in fact to act on the person's behalf in healthcare matters if the principal can. So it's similar to a supported decision-making agreement in the fact that it's a voluntary document, meaning the person signs it because they want to sign it, not because they have to. And it generally can be revoked or canceled. However, it is different from a supported decision-making agreement in an important way. Under a healthcare power of attorney, the agent or attorney in fact can make healthcare decisions for the principal if the principal cannot make them him or herself. The supported decision-making agreement doesn't allow for a supporter to make the healthcare decisions for the person. And just a note that despite the terminology, it can be a little confusing because it uses the term attorney in fact. The representative does not have to be an attorney or a lawyer. The authority of the agent or attorney in fact is what's called springing, meaning it doesn't take effect right away as soon as the document is signed for the most part. Before an agent can exercise the authority conveyed by a durable power of attorney for healthcare, two licensed professionals in DC, a physician and a psychiatrist or psychologist, have to certify in writing that the principal no longer has the mental capacity to make their healthcare decisions, even if they're getting support from others. A durable power of attorney for healthcare can give an agent a multitude of different powers, depending on what the person wants, including the ability to review medical records, to receive information necessary to make informed healthcare decisions, to make decisions involving medical treatment, healthcare delivery, and end-of-life choices, to grant, refuse, or withdraw consent to any treatment or procedure, to make decisions about admitting to or discharging from healthcare facilities. And in a durable power of attorney for healthcare, the principal, the person signing it, they can include limitations on the agent's powers and specific instructions for end-of-life treatment and care. And the person creating the power of attorney, they can appoint a family member, a close friend, a trusted advisor, or some other trusted adult in their life to be their healthcare agent. A durable power of attorney for healthcare, it's a pretty important part of the advanced planning process. Working with seniors, I often receive calls from people who have been diagnosed with things like Alzheimer's, dementia, memory loss, or some kind of cognitive decline. And they're expressing interest in creating a healthcare power of attorney so that they can have a plan in writing in case their condition progresses or worsens. It's something that we generally encourage folks to consider doing regardless of age or medical condition, because it's really better to have a plan in place than to risk having a situation where like your loved ones are fretting and worrying about how to manage healthcare, how to make really important medical decisions if the person becomes unable to make them. And I emphasize that the person signing the healthcare power of attorney, though, they are giving someone else the authority to make some pretty important and sensitive healthcare decisions on their behalf if they become unable to make them. And that is done without review or supervision by the courts. So giving someone that power, it can have some pretty serious consequences. Therefore, it's really important and absolutely critical that the agent or attorney, in fact, be someone that's trustworthy, that's reliable, and will, be there when you need them, that they have sound judgment, and that they have the time, availability, and capability to serve as a healthcare representative.
and that they have the desire to fulfill the responsibilities described in the document in the healthcare power of attorney,
and that they understand the person's wishes and that they're willing to follow those wishes. Before creating a power of attorney for healthcare, the person should discuss their preferences and their wishes with the person they're thinking of appointing as their agent to make sure that they really understand what their wishes are and that they're going to be willing to comply with those. An agent has the duty to follow the wishes expressed in the durable power of attorney for healthcare. And if those wishes are not known and they can't be determined for whatever reason, then the agent must act in the best interests of the principal. Next slide, please. So the CCE guide contains a link to a sample form for creating a durable power of attorney for healthcare. The durable power of attorney for healthcare has to be signed and dated by the principal and 2 adult witnesses. The agent cannot serve as one of the witnesses, nor can the principal's healthcare provider, like a doctor or nurse who's working with the person, they cannot serve as a witness. And only one of the 2 witnesses can be someone that's related to the person by blood or marriage or adoption. If a person creates a durable power of attorney for healthcare, it's important that they give copies to the person that they've appointed to make decisions on their behalf or their agent, and also to their healthcare providers, and request that a copy be added to their medical records. So long as the person has the mental capacity to do so, they can change their document or cancel their document at any time. The change or cancellation should be made in writing, and it should be sent to the agent and to the healthcare providers. So should a person hire a lawyer to create a healthcare power of attorney? It's not required, but it's something that is generally, encouraged in order to make sure that the document meets all the requirements of DC law. I know I've seen a fair number of documents that have been sort of self-help or pulled off the internet that have not really been consistent with DC law. And also, a benefit of having an attorney help is that the lawyer can vouch for the fact that the principal had capacity at the time that they created that document. Next slide, please. All right, so people can also provide specific instructions to their agents and their doctors by creating some other additional documents. So one is the living will or advance directive, which provides information about end-of-life care. There's a popular version that's called 5 Wishes. And oftentimes a lawyer, if they're helping with these documents, they can combine the healthcare power of attorney and advance directive into one complete document. Another document is called the medical orders for scope of treatment, or the MOST form. And this is a document that allows a person to tell their doctors about their choices for specific treatment options, like a do not resuscitate order or their wishes regarding like a feeding tube. This is a form that's registered with the DC Department of Health. So it actually has the benefit of sort of following the person around to different DC healthcare facilities. This form, the MOST form, it's filled out with the doctor, and you can find more information and the template forms at the DC Health website at dchealth.dc.gov/most, M-O-S-T. An important note is just before completing these healthcare documents, it's really important to talk to your doctor about what your decisions are. Next slide, please. All right, so let's talk about how a durable power of attorney for healthcare is different from the legal tool known as guardianship, which is going to be discussed a little bit later on. So a power of attorney, it's different because it does not require court involvement. It is a voluntary document. It's sort of driven by the person. So it's the person who's deciding what power they want to give and who they're choosing to give that power to. So it's the person deciding. It's not the court that's making these important decisions. Additionally, the person has the option to change their document or cancel the POA or power of attorney without having to go to the court and seek approval. Next slide, please. Okay, so here's an example of a situation involving a durable healthcare power of attorney. Anne has been diagnosed with early stage Alzheimer's disease. Her memory loss is mild so far. She wants to continue making her own healthcare decisions as long as she can with the help of her daughter, Jaleesa. When Anne can no longer make decisions, even with support, she wants Jaleesa to make them for her. Anne and Jaleesa discuss what kind of help Anne needs and wants and how this support will change over time. Anne decides to meet with a lawyer to create a durable power of attorney for healthcare, which states that in the event that Anne is properly certified as unable to make decisions for herself, Jaleesa will act as her mother's agent. The durable power of attorney for healthcare document includes a special provision authorizing medical providers to release health information about Anne to Jaleesa immediately. So the example kind of shows how the power of attorney, it can serve Anne's goals by leaving her to make her own medical decisions as long as she's capable, while allowing her daughter to step in if Anne ever gets to the point where she cannot make those decisions herself. And it also allows her to get the support that she wants right now by allowing her daughter to obtain medical information. Next slide, please.
So what if support decision-making for a DC Durable Power of Attorney for Healthcare will not work? The DC Healthcare Decisions Act allows a family member, friend, or other adult to make healthcare decisions on behalf of a person who, 1, does not have a durable power of attorney for healthcare, 2, cannot execute one, and 3, has been certified as lacking the mental capacity needed to make healthcare decisions on his or her own. And under the Act, 2 DC licensed professionals, either a physician and a psychiatrist or a psychologist, must certify in writing that the person for whom a substitute healthcare decision maker is sought lacks the mental capacity to make medical decisions. Please refer to the CCE guide for a description of the rules governing how these certifications must be completed. In this context, mental capacity refers to the ability, with or without the support of others, to understand the risks and benefits of a healthcare decision, choose among options, and communicate the choice clearly. And both professionals must give an opinion about the cause, nature, degree, and expected duration of the mental capacity. And the certifications establish incapacity only with respect to making medical decisions and may not be used for any other purpose. And the certification should be narrow in duration and scope because many people with disabilities over time may be able to develop or recover their mental capacity. Next slide, please. Subject to certain exceptions specified in the statute, a substitute healthcare decision maker may give, refuse, or withdraw consent for any healthcare service, treatment, or procedure. The exceptions include abortion, sterilization, psychosurgery, electroconvulsive therapy, and certain behavioral modification programs. A court order is required to override these exceptions. And whenever a substitute healthcare decision maker grants, refuses, or withdraws consent on behalf of a person, there must be at least one witness present. A substitute healthcare decision maker is usually a parent or sibling of a person with a disability or the spouse or adult child of an older person. A healthcare provider, including a healthcare facility owner, administrator, or employee currently treating or providing services to someone, cannot serve as a person's substitute healthcare decision maker. The statute specifies the order of preference for who may serve as a substitute healthcare decision maker. In terms of the removal or replacement of a substitute healthcare decision maker, the DC Healthcare Decisions Act does not expressly authorize a person to choose who will be his or her substitute healthcare decision maker, nor does it expressly authorize a person to end the substitute healthcare decision maker's powers. For these reasons, this tool should be used only if less restrictive alternatives, such as a durable power of attorney for healthcare, are infeasible. A person who does not want a substitute healthcare decision maker may challenge the certifications of incapacity by getting a written statement from their psychologist, psychiatrist, or doctor that he or she has a mental capacity to make healthcare decisions. And a person who wants to replace a substitute healthcare decision maker with a durable power of attorney for healthcare can do so by getting written declarations from 2 healthcare professionals stating that the person has a mental capacity to make his or her own medical decisions. And someone who wishes to be the healthcare decision maker, but who is lower on the preference list than the current decision maker, may petition the DC Superior Court and seek to show a better knowledge of the person's medical wishes, or if those wishes are unknown and cannot be determined, a better ability to make decisions in the person's best interests. Next slide, please. Let's now discuss an example of a substitute healthcare decision maker. Maria, who just turned 18, has cerebral palsy and profound intellectual disability. She's not able to communicate with words, although she continues to work with her special education support team to learn sign language. Her dentist recommends oral surgery, but does not believe that Maria can understand the risks and benefits of the procedure well enough to provide informed consent, even with the support of Esperanza, Maria's mother and primary caregiver. Esperanza considers becoming Maria's healthcare agent through a power of attorney, but it does not seem like Maria understands the power of attorney form, which is one of the rules. Instead, Esperanza gets written certifications from Maria's physician and psychologist that at this time, Maria cannot make her own healthcare decisions. Esperanza becomes Maria's substitute healthcare decision maker with authority to grant consent for the surgery. Next slide, please.
All right, so we're going to move on to discussing guardianship. If you recall one of the first slides at the beginning of the presentation with the list of different legal tools, guardianship was the last one, the one at the bottom. Guardianship, it's a court-based process, so it's a little bit different from some of the other tools we've discussed because only a court can establish a guardianship. And in order to establish a guardianship for someone, the court has to make two specific findings. So first, the court has to find that the person's ability to receive and evaluate information effectively or to communicate decisions clearly is so impaired that the person cannot manage their health, safety, finances, and other needs without the appointment of a guardian. The second finding they have to make is that there's no effective, less restrictive option available. So even if a person's ability to receive and evaluate information or communicate it is really impaired, so impaired that it affects their ability to manage their affairs, if there's a less restrictive option available, then a guardian shouldn't be appointed. So for example, if there's a person who has a valid healthcare power of attorney in place, then a guardian really should not be appointed for healthcare decisions for that person. If a judge makes these two findings, they may then appoint a guardian to make decisions on the person's behalf. This can include medical decisions or other kinds of decisions that we won't really get into today, based on what the judge determines the person needs. A guardian is responsible for helping, protecting, and making decisions for a person who lacks or has lost the mental capacity to make important life decisions or to manage their affairs. Although guardianship is needed in some cases, it really should be a tool of last resort because it is a pretty serious restriction of a person's civil rights. And just speaking for just a moment about LCE, although LCE does represent petitioners in guardianship cases, we really only do so if we do an assessment and really determine that there's no less restrictive option that would be available. And I'll pause for a moment since I mentioned LCE to see if any of my panelists have something they want to add about their practices.
Thank you, Jessica. So Quality Trust helps people seek to avoid or limit overbroad and undue guardianship. We do not represent people in guardianship court to get guardianship. We also help people explore alternatives to guardianship. And I think thinking both in the public sense of when guardianship is necessary, I think we all need to take a pause and do what Jessica said, really look through the less restrictive options first, because it's a serious step to take with guardianship.
All right, thanks, Morgan. Next slide, please. All right, so if guardianship is needed, who becomes the guardian? It really depends on the facts surrounding the case. It can be a family member or someone else that the person knows, or it might be a professional guardian appointed from what's called the fiduciary panel. The person can nominate who they want to be their guardian. Ultimately, though, it is up to the judge to decide who becomes appointed as that guardian. There are different types of guardianship that can be put into place for somebody. There's a temporary guardianship where it's limited in time. There's what's called a limited guardianship where a guardian is only appointed for certain, limited number of life areas. For example, a person might be appointed a guardian only for healthcare or only to manage a person's income. And then there's general guardianship. This is the kind that's most commonly seen, and it's when a person has a guardian appointed over most areas of the person's life. Guardians do have an ongoing responsibility to the court, or multiple responsibilities really, including a requirement that they have to submit reports every 6 months. And guardianships that were established in 2015 or later are subject to a review that's done every 3 years to see if there are any changes that are needed. Guardians are supposed to use a certain decision-making standard called substituted judgment. And this means that their decisions, are not supposed to just kind of come from, whatever they want. They're really supposed to think about what the person's beliefs and values and preferences are, and they're supposed to make decisions that conform as closely as possible to what that person's decisions would have been. So an example that I think of sometimes in terms of seniors is if a guardian is appointed and they know that the person wants to age in place in their home and they want to receive nursing services in their home, that they really should do everything they can to support that and effectuate that wish, and not, rush to do what they want, like perhaps place them in a skilled nursing facility. Next slide, please.
As Jessica previously stated, guardianship should be considered a last resort for numerous reasons. Guardianship is the heaviest tool in the toolbox to use on a person. And guardianship means that the court is taking away some of a person's rights to make important decisions about their own life. This is a very big step to take, and it can be expensive and a time-consuming process. Judges, lawyers, and other court officers will be involved during the process. It can be an invasive process. And changing or ending guardianship can be difficult and requires additional court proceedings and expenses. And guardianship can also limit a person's freedom and ability to exercise self-determination. And self-determination is linked to better life outcomes for individuals with disabilities. And that is why establishing a guardianship is a serious step that should be taken only after careful consideration, including an assessment of whether less restrictive alternatives will provide adequate support and protection. Next slide, please.
So let's turn to a concrete example about guardianship in the healthcare context. Edith, who has an intellectual disability, lives alone in an apartment and receives assistance from the DC Department on Disability Services, or DDS. She does not have any family members involved in her life. Although Edith works and manages her own money, she has trouble understanding medical information and making healthcare decisions for herself. She cannot turn to a family member to serve as her substitute healthcare decision maker under the DC Healthcare Decisions Act. That was the option that Holly talked about earlier, because she doesn't have any family members. Given her limitation, the Department on Disability Services requests that the Probate Division of the DC Superior Court appoint a limited medical guardian. The court appoints a limited guardian for Edith from its list of professionals who have been experienced in providing such services. And Edith retains all of her other decision-making rights other than those related to healthcare. I'm using this example because Quality Trust sees limited medical guardianship being considered more regularly for DC residents who are served by DC DDS. But in our opinion, this option should be considered more broadly for people with all sorts of disabilities. In other words, we should not immediately think a general guardianship is necessary. We should explore limited options first if all the less restrictive options are not going to work. So that includes for people not only with developmental disabilities or intellectual disabilities, but also people with age-related disabilities or those that are mental health related. Limited medical guardianship is a less restrictive option to general or plenary guardianship and should be considered as a possibility before jumping to the most restrictive form of guardianship. And because I shared quality trust position, I want to open the floor to Jessica to talk about this from an aging perspective.
Thanks, Morgan. Yeah, I don't really have anything to add aside from what I've already stated, but I do agree that in cases where a guardianship may be needed specifically for healthcare, that it should be limited to that if it's not needed for other areas of a person's life, and should be considered, more broadly as an available option for people.
Thank you so much. Next slide.
So that concludes our presentation. We have about 10 minutes left. If folks have any questions, you can either put in the chat or you can use the Q&A function. So I'll give a few moments if folks want to type their questions out, or if our panelists have any sort of parting thoughts that they would like to share.
I guess I'll start with some thoughts and some regular questions I get. I think out there are a lot of myths about guardianship and what it does or doesn't do. And I think a lot of misinformation or lack of information about available options and how that are less restrictive and how to access them. And I think, one of the great things about CCE's guide is it tries to demystify these kinds of concepts by giving people information that they need to know to be able to access those kinds of tools, as well as links to the forms to be able to access those tools. And I will say, just to give a plug to Quality Trust, our Jenny Hatch Justice project that Holly talked about can help certain eligible DC residents with disabilities, including those that are age-related, access those kinds of tools and answer questions about guardianship. I encourage people to take a look at the CCE guide as well as the attachments for it, and to reach out to Casey and Jessica and me and Holly if you have questions about those kinds of tools. So we got a question in here that says, please address court-offered complaint services on guardians. Carol Linning showed a post series 20 years ago. Oh, sorry, it's as bad as it can get. So there is a new complaint process. I guess it's relatively new, that went into effect as a consequence of some guardianship reforms that are out there. So it used to be that the way you could complain about your guardian was that you had to file something that's called a petition post appointment with the court to start a kind of more formal court process. Now, as a couple of years ago, there was the creation of a formal complaint process where you could submit a complaint to the Guardianship Assistance Program about a guardian, and it really could be anybody who submitted that kind of complaint, and you could try to seek some redress. I will say, I think the formal complaint process is another option for people, but in the experience of Quality Trust, it can also stall, and a person can benefit from legal representation during that kind of complaint process. But it can also trigger a review in a way that was intended to be less difficult to access than the more traditional court pleading form. Jessica, do you have anything to add about the complaint process?
I have seen situations where a complaint does trigger court review and possibly even a hearing, but I've also seen cases where nothing came from the complaint whatsoever. And so it is an available tool, but as Morgan said, a person would benefit from having counsel sort of help them navigate that process and ensure that their complaint is acted upon.
I agree. And I think that's even more true now during the court's certain kinds of constraints the court has because of COVID. things can get pretty snarled up in the court process, and I think sometimes advocacy is necessary to deal with that. Good question.
I'm gonna pop my email in the chat. Just if anyone has any questions afterwards, I'm happy to talk.
I think it would be great for all the presenters to do that. I think that's a great option. You know, some people might have specific questions that are more kind of fact specific, and they, you know, are shy about sharing that more publicly. And so I really do encourage people to reach out with questions that you may have, not only about like less restrictive options, but also about court processes like the complaint process that Fritz mentioned.
So while all of the panelists are putting their contact information in the chat, I just want to thank everybody so much for tuning in tonight, and thanking Holly and Jessica and Morgan for lending their time and their expertise for this webinar. And so with that, I will say good night to everybody. Thank you so much, everybody, for coming. I hope you have a great rest of your evening. We are doing 2 more webinars. This is the first of a 3-part series. The second part will be next week, and it's on education decisions. And the third part will be the following week, and it is on financial decision making. So please be on the lookout. Please tune in and have a great night.